Good morning, everybody. Today is Friday, April 18th. It is 8:47 a.m. This is the House Commerce and Economic Development Committee, and we are here this morning with our intern, Helen R. Graves. Good morning, Helen.
Good morning, everyone. For the record, my name is Helen Hargraves. I'm the legislative intern for the committee this session and a senior at the University of Vermont. This morning, I am updating you on my research on non-compete agreements, specifically a little bit of carryover on franchise-specific non-compete agreements from last week, and then I delved a little bit into healthcare non-compete laws. What I wanted to work on finding for franchise non-competes this week were some court cases. And I have a few to give an example. I contacted the NCLS last week and they were able to point me in the direction of a case in Wisconsin from 2003, in which a franchisee and franchisor terminated their agreement. And the franchisee felt that the restrictions in the non-compete agreement were unreasonable, and brought the case to the Wisconsin, I believe, Supreme Court. And the court essentially had to choose between a Wisconsin statute on non-compete agreements and the common law analysis. Wisconsin does not have a franchise-specific law like most states. Most states have a more general non-compete law. But in this case, it has sometimes been applied to franchise questions. That statute says that a covenant by an assistant, servant, or agent not to compete with his or her employer or principal during the term of the employment or agency, or after the termination of that employment or agency within a specified territory and during a specified time is lawful and enforceable only if the restrictions imposed are reasonably necessary for the protection of the employer or principal. Any covenant described in this subsection imposing an unreasonable restraint is illegal, void, and unenforceable, even as to any part of the covenant or performance that would be a reasonable restraint. The judge pointed out that in this statute, since the word franchisee is not included specifically, that indicates legislative intent to leave it out, and so chose not to use that statute in the decision. But he did cite another Wisconsin case where I believe it was determined that that statute only applied to employment relationships. So in that case, that wording was very important in determining this outcome. And seeing as that didn't fall under the Wisconsin statute, the judge proceeded with Wisconsin state common law analysis and concluded that the requirements prohibiting competing within 45 miles of the franchise territory for a period of 1 year were reasonable, and therefore the contract, the sections that stipulated those requirements were valid and enforceable. So that case was decided in favor of the franchisor. However, in H&R Block versus Lovelace in 1972 in Kansas, a case was appealed to the Supreme Court of Kansas by the franchisor. The agreement between the franchisor and franchisee prohibited Lovelace from competing in the tax return business for a period of 5 years after its termination, but did not specify a geographic scope. And when Lovelace terminated his agreement with H&R Block, he actually set up his own business in the exact same spot where he had been practicing the franchise. within that 5-year period. And a trial court decided in favor of Lovelace, concluding that the lack of specified geographic scope indicated the intent to limit competition from anywhere in the world for a period of 5 years, and that this qualified as unreasonable under state common law. The Supreme Court affirmed that decision and did not enforce the agreement because it was unreasonable. There's a case that is interesting, but I cannot find it anywhere on the internet, so I'm working on figuring out how I can get access to it. But California Pizza Kitchen Inc. versus Mangual in 2000 was a case where the California court reaffirmed the broad application of their non-compete statute and struck down the non-compete clause in a franchise agreement due to its potential to limit economic opportunities within the pizza industry. That is according to a law firm website that is linked in the document, and I am still working on finding out details about that. Moving forward, I was able to put together a list of some statutes that I was pointed towards by the NCLS regarding healthcare non-compete agreements. Pennsylvania just passed a bill last year, effective January 1st of this year, called the Fair Contracting for Healthcare Practitioners Act. The intent behind this was to address the issue that access to healthcare for Pennsylvania locals is very dependent on geographic region. And many of the healthcare practitioners in the state are employed by consolidated hospital systems. And so non-compete agreements enforced by them have the effect of greatly limiting patient access in that state. So the intent is to regulate that the ability of those consolidated hospital systems to enforce non-compete agreements on healthcare practitioners and increase the competition in the industry and therefore benefit both practitioners and patients. That bill declares non-compete covenants entered into after the effective date void and unenforceable, with the exception that a covenant not to compete must not last longer than 1 year. And it requires that the patients of a practitioner who is leaving their employer be notified if they have been seeing the practitioner for 2 consecutive years or more, of the fact the practitioner is leaving, the fact that they can follow them and how they're able to transfer their health records to a different employer, as well as the fact that they can choose to remain with the current employer and be assigned to a different practitioner within that system. In New Mexico, there's a much less specific statute that regulates enforceability of non-compete provisions. That statute says a non-compete provision in an agreement is enforceable upon the termination of the agreement, a renewal of the agreement, healthcare practitioner's employment with a party seeking to enforce the agreement. And that a non-compete provision is unenforceable if it is subject to the laws of another state or requires litigation in another state. That is all that statute covers. And then Kentucky only restricts non-competes for temporary direct care staff, and it does not apply to permanent staff. Connecticut, in a statute that addresses covenants not to compete involving physicians, became effective July 1st, 2023, and requires that the party seeking to enforce a non-compete agreement has the burden of proof when bringing a case to court, and requires that in order to be enforceable, a covenant not to compete must be necessary to protect a legitimate business interest, be reasonable in time, geographic scope, and practice restrictions necessary to protect that interest, and be otherwise consistent with the law and public policy of the state. And it specifically imposes reasonable restrictions that limits the duration of a non-compete to no more than 1 year and the geographic scope to no more than a 15-mile radius. And I found as well that in 2024, there are actually a bunch of healthcare specific non-compete acts passed. One was in Illinois, where non-competes for licensed professionals who provide mental health services to veterans and first responders are unenforceable after, if they were signed after January 1st, 2025. Because enforcing a non-compete in that situation is likely to cause an increase in cost or difficulty for any veteran or first responder seeking mental health services. Iowa had a similar act passed in April of last year, an act relating to and making appropriations for veterans and health and human services, including other related provisions and appropriations, and including effective date and retroactive applicability provisions. And that specified that healthcare technology platforms cannot restrict the employment opportunities of independent nursing professionals through a non-compete clause. Louisiana, these two states, Louisiana and Maryland, had what is termed by the Economic Innovation Group that tracks non-compete agreements across the states as healthcare bans. Louisiana's came into effect as of the 1st of this year, and says that non-competes restricting primary care physicians from practicing medicine will expire 3 years from the effective date of the agreement. And any subsequent agreements or renewals may not include a non-compete. And if the employment relationship is terminated within 3 years, the scope of the non-compete must be limited to 2 years in duration and to the parish in which the practice is located. Although I'm not 100% clear on what parish means in that context.
It's like a county.
Okay,
They're called parishes in Louisiana.
okay, perfect. Similarly in Maryland, non-competes affecting both veterans and veterinarians and healthcare professionals who make less than $350,000 annually are void whether or not the agreement was signed within the state. So that's similar to California. And for healthcare professionals providing direct patient care and earning more than $350,000, non-competes are limited in scope to 1 year from termination of the relationship and 10 miles from the primary place of employment. So those are the specific examples that I put together for today. I'm working on putting together another spreadsheet, which will allow me to put all of these side by side and link court cases as well as statutes. And then also I think it will be helpful to just do a side by side comparison of the different duration requirements, radius requirements, things like that. Yes, that is all that I have for you today. I'm happy to take any questions.
Great. Any questions?
I don't think so. I mean, I think the spreadsheet's gonna be really helpful. And that was interesting. I mean, I'm just flagging, it was interesting to see that limit of $350,000 for that income level and the 10 miles. So that kind of stuff is really helpful to understand kind of what some states are doing. So thank you.
I found it interesting that when they didn't mention a geographic area, it actually worked against them.
Yeah,
Fascinating.
it has to be very limited, I think, for it to be valid.
But kind of helps to define reasonable.
It does.
It does, yeah.
Yeah, if you could submit that for us, so we can, it's helpful to have, sometimes it's helpful to have it even, while you're giving your presentation. So
Absolutely.
beforehand is usually more better. Yeah,
Just to follow up on that, that upper income level, is that going to be one of the metrics of your spreadsheet?
I plan to include the different specifications, including income, position in a company. There was one, that I looked at where it specified, partner, owner, director. And I know you'd asked a question about that.
Yeah.
Last week. So those are things that I plan to include, yes.
The other thing I think will be interesting is, I don't think might not be possible for you, but it'd be interesting to see which states, where they have a healthcare specific non-compete. Different states have different degrees of consolidation. It'd be interesting to see where those healthcare specific non-compete statutes have popped up in relation to the degree of concentration of healthcare organizations.
Actually, that does bring up a point. I was just thinking about, in a situation where somebody sells a business, is that implied in some of these states that you can't compete? Like if I buy someone's IT business, which I've done in the past, and can I force them into a non-compete clause? Because if I can't, there's nothing to stop them from.
My guess is it's an allowed exception, like in our.
Yeah, it's in the bill.
an
I
exception.
know it's in our bill, but I'm curious if
Yeah,
that's,
yeah.
is that even something you need to worry about? Or,
I bet it's a standard exception.
Yeah.
Yeah.
That's what we're looking at.
yeah, I'd be
Yeah,
curious
it's-
to see if that's a standard exception.
Are
I mean-
you talking about,
litigated.
Yeah,
Yeah.
really, if it's been, you have a situation where somebody buys a business and they make that person, and they don't sign a non-compete. So what happens is they just paid, $500,000 for this person to buy the business, and then they use that capital to go into business against them.
It's usually called, I think it's a goodwill clause.
Yeah.
Right, yeah.
there's
Goodwill,
a,
that's,
I bought a business once and I had to sign, the woman who sold it to me had to sign off. She wouldn't compete for
yeah,
5
and I bought a couple of businesses and we've always had a non-compete.
those are in almost every state bill,
Okay,
state
that's good to know.
statute, yeah.
Great. Anything else for Helen? All right. Thank you, Helen. So committee, that's all we have for this morning. We're on the House floor at 9:30 and they're estimating that'll take about an hour. And then we'll be back here 10 minutes after the floor for Senate Bill 117. Act relating to rulemaking on safety and health standards and technical corrections to employment practices and unemployment compensation. We'll have a markup of that bill. And I believe as the chair has said, the goal is to get us out that we can be done by noon. So that's all we have, unless any of you have anything you want to say right now. Otherwise, we'll.
At one point, it was possible vote on that. Is that not the case now? Do you know?
It's possible what?
On 117, I can't remember whether it's markup discussion. Is it possible vote, do you know?
It's a possible vote. If
I'll start reading.
if there isn't too much, concern fiddling with it. So we'll have the commissioner in and the director of workers comp and the city council go over it. If you've looked it over, it's a lot of technical correction things. So
Yeah, I don't recall it's been real contentious here. So.
I skimmed through it and nothing.
Yeah.
great. So make good use of your